Good day, I'm Ming from Taylor School of Law and Governance. The first legal issues involved in the distribution of Anthony's estate was whether the 2018 will executed by Anthony was valid. According to Section 2 of the Wills Act 1959, a will is a legal declaration of a testator's intention regarding the distribution of their property and other wishes to be carried out after death. In this case, Anthony executed a will to dispose all of his movable and immovable property after his death to appointed beneficiaries. For a will to be valid, there are certain requirements at the time of making the will. Firstly, the testator must be over the age of majority. Under Section 4 of the Wills Act 1959, any will made by an individual under the age of majority is invalid, which is the age of 18 according to Section 2 of the Age of Majority Act 1971. In this case, Anthony, who aged 21 while making a will, was above the age of majority and capable of making a valid will. Next, the testator must have the intention of making a will according to Section 2 of Wills Act 1959. In the case of Lister and Smith, it was held that a will not be considered valid without a genuine intent to dispose of property. So, the test is whether the testator intended the document to distribute property upon their death or perform any other function a will can achieve. In fact, Anthony's language regarding property distribution and his arrangement for an executor to execute, administer, and distribute the estate upon death accordingly had shown that he had the intention to make a will. In this case, Anthony appointed David as the executor to administer his estate according to the 2018 will. An executor is a person chosen to administer the testator's property and carry out the will stipulation. There's no restriction whatever exists upon the choice of an executor, considering that the executors have full capacity to receive a grant of representation. Besides, Anthony must have testamentary capacity while making the will. The test of testamentary capacity was laid down in the case of Banks and Goodfellow, that the testator must have the capacity to understand that he is making a will, and the effect of his testamentary disposition, the extent of his or her estate, and therefore the property that can be disposed of in his or her will, and those who have claims on the estate. The understanding must not be impaired by any disorder of the mind or delusion. In this case, the fact did not show that Anthony was suffering from mental disorder. Also, based on the Banks test, Anthony was likely to have the testamentary capacity to execute the will, as he understood its nature of making a will by writing the will and left all his property to Bob, Charlie, and his future wife equally. Next, at the time of making the will, Anthony must have exercised his genuine free choice. Since Anthony was not making the will under coercion, fraud, undue influence, and mistake, he did not lack free will in making the will. Move on. The 2018 will not be regarded as valid will if it does not comply with the formalities set out in Section 5 of the Wills Act 1959. Firstly, according to Section 5, subsection 2 of the Act, the will has to be in writing, while in this case, Anthony wrote the will himself. Also, a will must be signed by the testator or by another person on behalf of the testator. Yet, the signature must be placed at the foot or end of the will. Additionally, the testator must sign the will in the presence of two or more witnesses present at the same time. So, in the case, Anthony signed the will in front of Bob and Charlie. Also, it is prudent to ensure that the attesting witness is of sound mind, not a minor, and if required, should be able to testify in support of the execution of the will. While in this case, since Charlie was instructed to keep a copy of the will, indicated that Charlie was of sound mind. Also, the witnesses must subscribe the will in the presence of the testator. According to the case of Dr. Shanmuganathan and Periyasamy, there's no requirement that the witnesses must subscribe the will in each other's presence. Back to the case. Although Bob and Charlie signed to subscribe the will as witnesses without each other's presence, it was sufficient that Anthony had seen them to subscribe, although on different days. However, it is important to note that the witnesses cannot be persons who benefit under the will. According to Section 9 of the Wills Act 1959, gift to an attesting witness will be void, but Section 8 provides that a will is not invalidated by reason of incompetency of attesting witnesses. In short, since Bob and Charlie were listed in the 2018 will, they will no longer benefit under the will. In a nutshell, the 2018 will was a valid will since it fulfilled the requirements of a valid will. The next issue was whether the marriage between Anthony and Stella revoked the 2018 will. According to Section 14 of Wills Act 1959, a will may be revoked by marriage after making a will. Also, Section 12 of Wills Act 1959 states that a will is revoked on marriage. The revocation of a will made prior to the marriage is automatic and takes effect without the testator so intending or indeed even contrary to his intention, according to the case of Marston and Rowe. In the case of Lim Kai-chi, the will made by a married man was revoked by his secondary marriage. For the rule to operate, the testator's marriage must be one which is valid in law, while in this case, the marriage between Anthony and Stella was valid in law. Also, Section 12 sets out certain cases where marriage does not revoke a will, in which, for the proviso to Section 12 to apply, it must be apparent on the face of the will that the testator expected to be married to a particular person and not merely that he expected marriage in general. In the case of Sally's and John's, the pre-marriage will was revoked as the last line of the will merely stated this will is made in contemplation of marriage, without naming any specific person with whom the marriage was contemplated. In fact, Anthony executed a will leaving part of his property to my future wife without naming any specific person, merely an expected marriage in general, indicated that the 2018 will was being revoked by their marriage. Apart from that, Stella may challenge the will to be revoked by intentional destruction. Section 14 of Wills Act 1959 states that a will may be revoked by intentional destruction of the will, in which it must be shown that an act of physical destruction within the terms in this provision. The destruction has to be carried out either by the testator or by some other person in his presence and by his direction, and animus revocandi on the part of the testator. The issue was whether Stella's intentional destruction of the 2018 will revoking the will. In the case of Jill and Jill, it was held that the will was admitted to probate since the will was not being destroyed at the testator's direction and the testator did not have any intention of revoking it. From the fact, the act of Stella tearing the 2018 will and flushed the torn pieces down the toilet and did not indicate that the 2018 will was being revoked, as Stella conducted this act not by Anthony's direction. Anthony had no intention to revoke the 2018 will at the moment. In short, although the 2018 will may not be revoked by destruction, but the will was revoked by marriage. Hence, the next issue was whether the 2024 will executed by Anthony was valid. In 2024, Anthony was 27 years old, which reached the age of majority. Next, it had to be shown that Anthony has the intention of making a will. Since Anthony had appointed an executor, 2 witnesses, and a new beneficiary, evidencing that Anthony had an intention of making the will with different terms, as well as showing a genuine intention to make the 2024 will effective. Additionally, Anthony expressly suggesting that he considered to revise to exclude Bob and Charlie from the 2018 will, highlighting that Anthony had an intention of making the 2024 will. Next, following the bank's test, Anthony would have testamentary capacity as he understood that he was making a will and the effect of the testamentary disposition, as well as the extent of his estate, and therefore the property can be disposed of in his will, and those who have claims on that in which he appointed David as the sole beneficiary, leaving all his property to David. Besides, Anthony had exercised his free will in making the 2024 will, since he was not making the will under coercion, fraud, undue influence, and mistake. Next, the issue was whether the 2024 will fulfill the formal requirements of making a will which were set out in Section 5 of Wills Act 1959. The fact did not indicate whether the 2024 will is in writing. Hence, we will assume that the will is in writing, which complied with Section 3 of the Interpretation Act 1967 and was executed in the manner provided in Section 5 subsection 2. In this case, Anthony signed the will in the presence of Ed and Fred, which also fulfilled the requirement of at least 2 witnesses present at the same time. In addition, Ed and Fred had to be of sound mind, not a minor, and able to testify in support of the execution of the will, if required. However, the issue was Anthony left before Ed and Fred signed the will as witnesses. The principle was that the witnesses must subscribe the will in presence of the testator, and it is enough that the testator could have seen them subscribe if he wished to do so. In this case, since Anthony had left immediately after receiving a phone call and passed away in road traffic accident, hence, he could not have seen Ed and Fred sign as witnesses, as there was no chance for Anthony to see them signing when he rushed over to see his baby. The 2024 will was rendered invalid due to non-compliance with formal requirements. A will speaks from the death of the testator and up to the time of death is unenforceable and can be revoked or amended to suit changing circumstances. Anthony passed away in 2024. Since 2018's will was revoked by marriage and 2024's will was invalid, Anthony would be said to have died intestate, whereby intestate succession will take place. Total intestacy will occur since Anthony made no effective testamentary disposition of any the property of which he was competent to dispose by will. The estates of non-Muslims are governed solely by civil law. Since Anthony was domiciled in West Malaysia up to the time of his death, and assuming that Anthony was non-Muslim, the Distribution Act 1958 may apply in distributing Anthony's estate and not in accordance with his intentions and wishes. However, these rules are subject to the court's overriding power in relation to family provision under the Inheritance Family Provisions Act 1971. Section 6 of the Distribution Act 1958 sets out the detailed rules as to the distribution of the property of the intestate after payment of expenses of due administration. Potentially, spouse, issue, and so on may be entitled to all or some distribution of the intestate deceased estate. In this case, although Anthony had filed the necessary papers to divorce Stella, but the divorce petition was yet to be heard in court. Hence, Stella will still be considered as spouse of Anthony. A surviving spouse shall be entitled to the intestate's estate as long as the marriage was not legally dissolved by way of divorce or marriage was not annulled. Stella shall be legally entitled to Anthony's estate accordingly. Additionally, Georgina, the baby of Stella and Anthony, will be considered as issue since Georgina was a legitimate child of Anthony under Section 2 of the Act. The distribution after payment of debts and liabilities of deceased is laid out under Section 6 of the Act. In this case, there are surviving spouse and surviving issue. Hence, the shares will be distributed as 1/3 for Stella and 2/3 for Georgina with the condition that there is no surviving parents. In addition, the Legitimacy Act 1961 grants legitimated individuals and their descendants the rights to inherit from an intestate estate as if they had been born legitimate. In summary, Anthony's 2018 will was revoked upon his marriage to Stella, and the 2024 will was invalid due to non-compliance with formal requirements. Consequently, Anthony's estate will be distributed under intestate succession, granting 1/3 to Stella and 2/3 to their daughter, Georgina. Thank you.